Hey y'all! How are you today, mga mari, mga pari dyan? Thank you so much for dropping by again. And I am so delighted for all your help and for all your support back to my very first launch on my video on this channel. So thank you for supporting that. It just shows that we are all eager to know the role of law when it comes to international law. Well, we're not gonna say much more of blah blah. We're just gonna go ahead and straight back to the crucial discussions that we are going to cover in this first video. Was very long, and I'm sure you understand that because it was the introduction, and I want you to be familiarized with what is the vlog about, what is Legal Matters with Yen is all about. You would like this topic today. This is about labor code here in the Czech Republic, and I know we have like, correct me if I'm wrong, we have like about 5,000 Filipinos here in the Czech Republic. Maybe 3/4 of that are working, employed here in the Czech Republic, and probably tens of that are married to the local Czech here. So but aside for that, probably 5% of the who are working here in the Czech Republic, I'm sure they are facing their personal issues when it comes to their employment contract. So let's try to tackle that down in here. I'll bring up some of the questions from our kababayans here in the Czech Republic. That is for them is a redundant for them to justify their employment situations between them and their employer. So I answer all the questions that I have received already. This Labor Code of the Czech Republic was actually it was amended back in probably a decade ago, but before that it was before the Czech Republic became this country itself. It was, we all know that it is part of the Czechoslovakia, all right? So they have all those amendments together, and then later on they revised the new version so that the Czech Republic has their own provisions when it comes to labor law here in the Czech Republic. This video is about the Labor Code of the Czech Republic, the Labor Code number 262/2006, which is the Zákony praxe of the Czech Republic. The Czech Labor Code is our sources of law. It is our existing evidence to discuss about legal matters. So we are basing the evidence Czech Labor Code in this blog. Forgive me if I will keep looking to my screen because I wrote down what I wanted to say already, so that I won't be mumbling around. I won't go from jumping A to jumping Z and back to C, and I want it to be uniform so that I'm not gonna take time to talking of non-essential for now. Just go straight ahead to our employment issues in here. So first, the most common problems when it comes to employment is from the employment issues of employment relationship, the employment contract, employment benefits, or the provisionary period, or the termination, and the employee's salary deduction, and also the monetary band. I'm not gonna read all the labor code because you all know that the Czech labor law has about 390 pages more. So if we're gonna discuss section by section, I know it's gonna take us forever, or at least a day to run down the labor code of the Czech Republic. So just go ahead to the subject of this blog, and that is the labor code under the employment section. It's precise the standard agreement that in the labor code that mostly catches our attention because of the redundancy of understanding, and this grabs hopefully the crucial section of that context to get a precise knowledge of the labor code of the Czech Republic. And let's get a hang with this provisional law given to be implemented to enforce as the mandated legal action for this country. We all know that these provisions protects legal actions between an employees and the employer to implement a healthier relationships when it comes to employment contract. And all right, so let's tackle down this employment relationship first. The employment relationship, what is this one means? Regardless of the form of employment workers, you are here in the Czech Republic. You are entitled to the protection law of the Czech Republic in referring to the Czech Labor Code. We all know that. Under the Chapter 1, the procedure before the commencement of an employment relationship in Section 30, 31, and 32. What does this mean? This means that the stipulated sections are subject to be allowed and must come to a common agreement between the employee and the employer. What are these common agreements? First, the employer has all the legal rights to publish of what kind of job title she is or he is looking for. And because of that, you applied for the job for that position only. And the second one, the Section 32, is saying that the employer has the right to lay down his concerns and regulations to be in your employment contract, such as your responsibilities to the position, your salary condition, working condition, and so on and so forth. And the third one, the Section 33, is saying that once the second regulations by the employer come to a common agreement between you as the employee and your employer, then you as the employee must go further examination like medical exam and thorough discussion so that the formation of your employment contract will come to force. What does that one means? Means that once you agree the job, okay, once your employer accepted you the job, because that's the skill you are looking for as well, that is under the Section 31, and the Section 32 will be implemented, and that's all the negotiations between you and the employer. The negotiations is how much your salary, the deduction, and how much is your salary conditions, and where you're gonna work, what is the condition of your working environment. And the third one, once these two will be come to an agreement between you and your employer, the third one will come to force only if you have to undergo medical examinations and a thorough additional examination. Depends to your employer, okay? If the job doesn't require the medical examinations, and no worries about it, just then the formation of your contract will come to force. What is that one means will come to force? Means that that contract will be entered right away. Okay? So on the Section 33, 34, A, B, and C, at the Chapter 2 of the Labor Code stated that an employment contract is between you and your employer only. What does that mean? It said that in your contract, all the agreement that you and your employer had discussed, it has to be in a written agreement. That means that it has to include your personal data information, the title of your job, and your work address, start date of your work. All right, I'm sorry, I forgot about this crucial sections to include in this video, so I need to insert this in this area here. This is about the part 4 of the working hours and the rest periods of the Chapter 1, the common provisions of working hours and the length of working hours under the Section 78 under the Labor Code of the Czech Republic. This is a very crucial sections in here because it stipulated about the working hours of the employees, and that should be included in your contract as well. The shifting hours, and most importantly, is the overtime work. During your negotiations on the making of your employment contract, be aware that under your employment contract, actually your employer can order you for another extra hours of working. That should be a maximum of about 8 hours a week of overtime. Should mention for specific overtime working hours that you think you could implement per week. Only if this is stipulated on in your employment contract. Just overtime is only maximum for 8 hours a week. So for example, you were working from 10 in the morning until 6 p.m. Let's say starting from Monday, you can add 2 hours in that. So instead of going home at 6 p.m., you can add 2 more hours for that, and you can get off your work at 8 p.m. and then the next day, which is Tuesday, is another 2 hours, and then Wednesday is only 1 hour, and that is Thursday and Friday. That covers you the 8 hours of your overtime working hours for the week. If you agreed on that 45,000, including the overtime, which is the 8 hours a week, if you think that that is good for you, then make sure that you have to do that and give that overtime to your work. But it doesn't mean that you have to go for an overtime every week. It doesn't mean that you have to go there to get an overtime every single day so that you can cover the 8 hours per week. No, it's not. And another one, if your employer mandated you to go for an extra overtime, and you know that this overtime period doesn't exist on your employment contract during the negotiations, during the making of your employment, then you have the legal right to declare an extra additional remunerations or extra pay for that. That could be the possible, like for example, in your 45,000 gross salary, and you said, okay, I'm gonna work extra for let's say in that week for 8 hours, okay. As we already saying earlier, you divided it, the 8 hours for that 5 days, because you cannot work 16 hours a day. That's gonna be a hilarious for you. It's gonna be a tremendous exhaustion for you. You're gonna be exhausted the next day. You need to sleep. You need to rejuvenate it. So what you're gonna do is you can ask your employer that you're gonna work extra time for the next week because we have a deadline to work on. Then you can ask how much is your remuneration for that. This means an extra pay. I'm sorry for that terminology. Let's say for the 8 hours that week, okay? I know you will get a compensation of extra hour for your overtime, especially during the night shifting. That should be about 25% of your hourly salary rate. Remember that. And that negotiations is between your employer and you. And another one is that your employer is mandating you to work extra Saturday and Sunday, and you know that is your day off. If you think you can work on the weekends, then go ahead, but make sure that you also get an extra compensation for that days. Again, the maximum of weekends work is 8 hours per day. So you have an 8 hours on the Saturday and another 8 hours on Sunday. That's the maximum. But if you think you still can work over the 8 hours on that day as an additional, it's an overtime, it's up to you. But no one will gonna force you to work extra for that, unless if you really want an extra paid for that. It's up to you. Okay, this agreement of the weekend works is between you and your employer only. You have to make sure that your discussion will come to an agreement between you and your employer, a mutual agreement to end up to this kind of compensation for you to receive during these extra hours of work. And additional for that is that only if these extra works during the weekends are not included on the making of your contract, then you have the legal right to command an extra remuneration for that, or extra pay or compensation, whatever you call it. Make sure that your employer is aware for this kind of situation. Don't just go to your office or to the constructions on that weekend, on that Saturday, because you want an extra work. No, you have to let your employer in advance that you are going to work on the weekends, if it's possible, of course, because you need some extra part-time or extra work. And make sure that your employer is aware that you are working between these hours of weekends. Okay, let them know. Every contract between an employee and an employer, it has to come up with a mutual agreement. It's not just because it's not just between you know about it and the other parties doesn't know about it. No, it doesn't work that way. It has to be every contract should be agreed between you and your employer. Alright, hopefully this one is very clear to you and understand all these details. This is under the part 4 of working hours and the rest periods of the chapter 1 common provisions of working hours and the length of working hours, and that is the under section 78 under the Labor Code of the Czech Republic. Alright, so we are also talking here about sick leave benefits. As an employee, we are entitled to have those sick leave benefits. Okay, it is stipulated in the Labor Code of the Czech Republic, and that is your right to receive the benefits. Your employer has an obligations for you to give you an approximately of 60% of your salary. The first 3 days is you get a sort of compensation, and then the next 14 days you will get a compensation from your employer again, and then for 15 days you will get a benefit from your health insurance. That is the maximum of 380 days. This is why it's important that you have to make sure that your employer is contributing your health insurance, because when you get sick, you are entitled to receive this kind of benefits as well. We will discuss the health insurance down here. We are still in the employment benefits. Okay, so you are also entitled to get sick leave benefit even if your employment ended and you get sick in 7 days after the ending of your contract. Okay, remember that. This is the paid leave of absence. It's saying here that you are entitled to get a paid leave of absence if you're going to a wedding of your child. Okay, only to your child, not your friends. Okay, so we're not entitled to that. You're only for your wedding, of course. And you can get a transportation of your wife to the maternity hospital round trip. You can get that. And also, hopefully, knock on wood, the passing of your spouses and your partner or your child. And You're also gonna get a paid leave of absence during your presence at the funeral of your spouse, your partner, your parent, or your child, or your siblings. This is only a matter of your immediate family only. And then you're gonna get as well a paid leave of absence when you go for outpatient checkup. Like you'll have a very quick surgery and you have to be there in the morning, and then you can come home on the night. That's a very quick surgery patient treatment. So with that, you can get your leave of absence.